Endorsement, yes. Endorsement, the two invisible signatures of power. Imagine signing a check and unknowingly transferring the title to your property, your rights, or your freedom. In this episode, we expose the hidden power behind two deceptively simple terms, endorsement and endorsement. These aren't just spelling variations, they're legal mechanisms that separate winners from losers in commerce and court. One of the least understood, yet most powerful distinctions in commercial law lies in the nuanced difference between the words endorsement and endorsement. Though frequently used interchangeably in casual conversation or by clerical staff, these terms have legally distinct meanings, especially under Uniform Commercial Code, UCC, Article 3, which governs negotiable instruments. According to UCC Section 3-204, an endorsement is a signature that is made on a negotiable instrument for the purpose of negotiating it, restricting its payment, or incurring liability on the instrument. The UCC uses the older legal spelling endorsement as a technical term distinct from the modern spelling endorsement. Endorsement typically refers to the original signatory who places the signature on a note to authorize its initial negotiation or transfer. Endorsement generally refers to secondary transfers, such as checks or existing negotiable instruments that are being redeposited, assigned, or resold. In practice, when you sign a mortgage, a car loan, or swipe a credit card, you are producing a negotiable instrument that, upon signature, can be treated as currency or collateral. The manner in which you sign that instrument, particularly whether you use a blank endorsement or a special endorsement, determines how much control you retain over it after delivery. A blank endorsement, UCC Section 3-205A, does not name a payee and allows the instrument to be transferred freely by mere possession. A special endorsement, UCC Section 3-205B, names a payee, creating a direct, traceable path of liability and entitlement. Banks overwhelmingly prefer blank endorsements from borrowers. Why? Because a blank endorsement converts the instrument into a bearer instrument, which can be sold, pledged, or used as collateral without notifying the original signer. This creates a legal fiction. You believe you owe a debt, when in fact your endorsement already paid the bank through monetization. When the public learns that they have the legal authority to restrict endorsements using terms like without recourse or by naming the bank as payee, the system begins to unravel. Such actions trigger immediate administrative concern within financial institutions because they interrupt securitization, deny liquidity harvesting, and expose the reality that your signature, not the bank's capital, is the basis of all lending. Footnote: this section explores the legal distinction between endorsement and endorsement and explains how the way you sign a negotiable instrument determines whether you retain or forfeit control over the financial asset.